Hello, and thank you very much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal. And Scott Legal is an immigration law firm, and we focus on providing immigration solutions to our clients. Now, this webinar is going to focus on moving from a non-immigrant visa to a green card, and we're going to use E2 as an example, but we're also going to go over other non-immigrant visas and moving to a green card with those other non-immigrant visas. Before we get started, a few housekeeping items. This webinar will be recorded, and when we're done with this, we will post this webinar to our YouTube channel, so you will be able to see this, and we do advise you to subscribe to our YouTube channel so that you are able to receive many other updates, because we do regular webinars on our channel, and we also post other informative immigration videos. We will get to all questions in the webinar, so if you do have questions, put them in the Q&A box or into the chat, and we will answer all relevant questions. And then the final thing is we will send you information after this presentation. We'll send you the PowerPoint presentation. We'll also send you the link where you can see the video and also information on how to set up a consultation. So without further ado, let's jump right into the meat and the presentation. And so the first thing I want to talk about is just really how the green card system works in the United States. And as I said, we're going to use E2 as an example, moving from E2 to a green card, but we're going to talk about other moving from other non-immigrant visas to a green card as well, and how that happens. But before we do that, just looking at how the green card system works. So the green card system is very different from other countries in the world. For example, in Canada, the Canadian system uses a points-based system where you get points for different things like education, the language, how long you've been in the United States, et cetera. And when you have a certain number of points, then you're eligible for permanent residency. In the United States, unfortunately, it doesn't work that way at all. And instead, the way that it works is that there are green card categories, and if you're eligible for a green card, then you can simply apply for one. So there isn't a green card that someone might have. So if someone has an O1, and there's a non-immigrant visa that someone might have. For example, if someone has an O1, or if they have a TN visa, or if they have an E2 visa, and then they've been in the United States for 10 or 15 years or something like that, and they have other traits like language or education or experience, etc. There aren't any non-immigrant visas that lead to a green card. And then so the system's broken down into primarily family-based and employment-based. There are others, but we're going to focus on the family-based and employment-based. And under the family-based green cards, there's further categorization of immediate relatives, which is defined by the government of if you're a U.S. citizen marrying a U.S. citizen. Non-immigrant, someone who's not in a green card, or a U.S. citizen that's marrying a U.S. citizen, or a U.S. citizen that's over 21 that wants to sponsor their parents. So those are the immediate relative categories. And then the preference-based categories are other categories. So, for example, a U.S. citizen that wants to sponsor their spouse. The U.S. citizen that wants to sponsor their brother or sister, for example. The spouse is the immediate relative category. The preference category example is the U.S. citizen who wants to sponsor their sibling. So the employment-based categories are broken out into EB1 through EB5, and EB1 being extraordinary ability, EB2 being the category which is either national interest waiver or what's called PERM, which is company sponsoring you for a green card, and then EB3, which is company sponsoring you for a green card. EB4, it's religious-based visa. We don't really do those. And then EB5, which is the investor-based visa, which is investing 800,000 or 1,050,000. So let's talk first about family-based. So you could have a situation where someone is on an E2, or they're on an O1 or a TN, and then they meet the love of their lives, and they get married. And that would be an example of the immediate relative category. And then the U.S. citizen could sponsor that person for a green card. So that happens all the time, and it's a popular way that people move from a non-immigrant visa to a green card. Now, when we look at the preference-based categories, there are a bunch of them. So they range from F1 through F4, and then subcategories as well. So the one example I gave you is U.S. citizen that wants to sponsor their sibling. Another one might be a green card holder that wants to sponsor their child, or a green card holder that wants to sponsor their spouse. But there are a number of different preference-based categories. And the thing you have to keep in mind with those, though, is they are backlogged. So under the immediate relative category, the green card is always available. Unfortunately, under the preference-based category, it's not. So depending on which country you're from and which category it is, there could be a delay. So for example, the example that I gave you where U.S. citizens sponsoring their sibling, it would be 14 or 15 years before that particular green card category was available, and there's no immigration benefit that the person has during the time that they're waiting. And all of them, even when we talk about employment-based green cards, they all work that way in the way that the government is allowed to issue a certain number of green cards per year. Once that number has been reached, then everyone else gets put in a queue, on a wait list per se. So and a lot of the categories these days are delayed. So the other thing to keep in mind with a green card, and this kind of it comes into play with all of the green cards when you're moving from a non-immigrant visa to a green card, is that the applicant is either going to do a two-step process or a three-step process. So they're going to first meet the requirements for the objective side. So for example, if you're marrying a U.S. citizen, you have to prove that it's a bona fide marriage. Then they are going to have submit documentation. If they're in the United States, it might be adjustment of status documentation, an I-485 petition, and if they're outside of the United States, they're going to do consular processing. So this piece is really related to the actual green card and really checking to see if the person have any factors that might make them inadmissible. And then the final, if in some cases there's going to be a third step, EB5 is a good example where there's a third step where you have to remove the conditions. Another example of where there's a third step is if a U.S. citizen that's marrying someone, then at the end of 2 years, you have to prove that the marriage is still a legitimate marriage. So that's something to keep in mind. So the first kind of moving from a green moving from a non-immigrant visa to a green card that we're going to talk about is EB1A, and usually the people that move to this category are people that are on O1 visa, and the O1 visa is similar to the EB1A visa in that you are showing that you've risen to the very top of your field, and the O1A in particular, the criteria are very, very similar to the EB1A criteria, and really what you have to do is meet at least three of the criteria that are listed on this slide. And all of them are really getting at that you've risen to the top of your field. And as a result of that, you should be eligible for a green card. And although the criteria are very similar to like O1 is very similar to EB1A, I almost think of it as EB1A is O1 squared. So whatever you have on O1, you're going to have more on EB1A to qualify. The next area where we see people commonly moving to a green card is EB2 national interest waiver. Now, EB2 has two elements. One is just company sponsoring you for a green card, and the other one is national interest waiver. Both of the elements under EB2, you do have to first meet threshold considerations of either having an advanced degree, so that's going to be a bachelor's degree or higher, a master's degree or higher rather, so either a master's degree or a PhD, or equivalent, which is going to be a bachelor's degree plus 5 years of progressive work experience, or exceptional ability, which, so let's say someone has a high school degree, there are 7 criteria, and if you look at those criteria and the person has met 3 of them, then they could qualify under the exceptional ability rubric, even though they don't have an advanced degree or a bachelor's degree plus 5 years. So then once someone has met those threshold requirements, then they move to the tough part, we'll say. And we do see a lot of people moving from E2 to EB2, and we see also people moving from H1B to EB2, and sometimes other categories as well, because it is a popular category for those who qualify. And really, you're showing that you're coming to the United States to do something that's of national importance and has substantial merit. It could be that you're coming to create jobs. It could be that you've invented something. There is going to be a big focus on expert letters, either proving that what you're doing is is of national importance, and maybe sometimes also proving that you're well positioned to advance the endeavor, which is the second requirement. And there you're going to be looking at the education, the experience, but also more importantly, you're going to be looking at whether the person has a track record. And then finally, you're going to want to put documentation or show documentation that the person, why the government should waive the labor certification, because the government has already said that the protecting U.S. jobs is of national importance, so that you would include additional information to show why it is they should, in fact, waive the labor certification. Now, and one thing to keep in mind with all of these is that these are all green card options that are quite extensive. And in this presentation, because we're talking about a number of different green card options, we are going over them at a fairly high level. And we do have individual webinars for each of these. So there's a EB2 National Interest Waiver webinar where we spend almost 45 minutes going over all of the EB2 National Interest Waiver requirements. So we do encourage you to attend those webinars as well if you want more information on these topics. Now, for both EB1A and EB2 National Interest Waiver, one thing to keep in mind is that the both of them, you have the ability to self-petition. So you don't need an employer to sponsor you, and they each are going to be a two-step process where you're filing the I-140. So if you're filing it for EB1A, you'll be filing the I-140 to show that you've met at least 3 of the 8 criteria. If you're filing the national interest waiver, you're going to be filing an I-140 showing that you're coming to the United States to do something that's in the national interest and has substantial merit, and you're well positioned to advance the endeavor, and that the government should waive the labor certification. Then with these, depending on whether the category is current, because EB1A is current for most countries, but EB2 is not current for any country, so you may have a bit of a wait. You're going to file the I-485 or consular processing, depending on whether you are in the United States or outside of the United States. And then the final thing to keep in mind here is that if you are in the United States and you file an I-485, you are permitted to file an I-765 and I-131, and that's the work authorization and travel authorization, respectively. So that is, you really will have all the benefits of the green card while you are in the United States. The next way that people move to a green card is company sponsoring them for a green card. So sometimes someone might be on an E2, and while an E2 can't sponsor the individual or the spouse, their spouse might be able to get another job or have another job because they have work authorization, and their company might be able to sponsor them. So that's one way. But in all categories, H-1B, TN, E3, there are many, many categories where someone might be working for an employer, and then the employer decides to sponsor them for a green card. So this is a very common way that people move to a green card in the United States. Now, it's a 3-step process. The first step part of the process has to do with the Department of Labor, and it's called a labor certification. And you have to show that you cannot find a qualified U.S. worker. So there's a specific job description that's developed, and there's a certain wage that has to be paid. And then the company has to go through a recruitment process, even though there isn't a real job, someone already has it. And then once that's been approved, then the I-140 can be filed. That's the same form that we talked about just now with the EB1A and the EB2. And in this case, though, you're going to be proving that the person has the qualifications for the EB2 or EB3. And EB3 can be lots of different things. It can be unskilled labor even. I've seen green cards approved for dishwashers. So although it's difficult because it's hard to prove that you can't find a qualified U.S. worker. Then the I-485 is again, we're going to file whether, depending on whether or not the category is current. The last employment-based category that we're going to talk about is EB5, and we see a lot of people move from E2 to EB5, and that sometimes they use their own E2 business. Then you see also a lot of people on H-1B, TN, and other non-immigrant visas investing in regional centers. So even people on B1 investing in regional centers. The direct investment is someone who's starting their own business and or investing in another business. The regional center is more of a passive form of investment where you're investing in a project that someone else is driving. The investment amount is going to be 800,000 or 1,050,000, depending on where the business is located. You do have to invest the money. You have to have possession and control of the money. If the business is located in what's called a targeted employment area, then it's 800,000. If it's in any other area, it's 1,050,000. It does have to be investment, like money that you've actually invested rather than retained earnings. So if you have an E2 company that's earning money over time, you can't just use that money as the investment. You have to have possession control of the funds and invest it into the entity. The other big thing with EB5 is you have to create jobs, 10 full-time jobs. You have to create, if you're doing the direct investment, you definitely need a strong business plan. Even a regional center is going to have a business plan. And the investment has to be linked to job creation. So that's something to keep in mind. And the 10 full-time workers, the 10 workers have to be full-time, and they have to be U.S. employees or green card holders. The source of funds, as I said, a lot of people move from E2 to EB5. The source, both visas have the source of funds requirement, but the source of funds requirement for EB5 is much more extensive. And then the EB-5 filing, it's going to be an I-526 petition for most categories, especially when it is the $800,000 investment. The category is current right now. So you can, in many cases, file the I-485 at the same time. And if you do that, you can file work and travel authorization. So it can really give people an ability to stay in the US for some time. But keep in mind that the application does take a long time to be approved, sometimes 4 to 5 years. And then after you've had the green card for 2 years, you would file an I-829. And when you file the I-829, that is really showing that you have actually created the 10 full-time jobs. The other green card options that people, people are on non-immigrant visas and they move to diversity lottery, that's coming up this October. So, definitely keep your eyes open for that. Sometimes humanitarian-based green cards when you help police solve a crime, or if you're a victim of domestic violence, you can get a green card. So those are other options. Sometimes people can get asylum can result in a green card. Um, the immigration reform is something that we hope for, but nothing we've seen any movement on recently. You always have to consider when you are moving from a non-immigrant visa to a green card to timing considerations, because sometimes the adjudication process takes a long time, sometimes years, sometimes 5 years in the EB-5 context. So you do have to make sure that you're maintaining underlying status. So that's something to keep in mind. And if you have a visa that's a single intent visa, like TN or E2, then you have to really keep in mind, because you don't want to be in a position where you have a pending green card application and you are filing for a renewal. Sometimes people apply for multiple green cards at the same time, and so parallel green card strategies is something that is very common and even, to some extent, even encouraged. So. Perfect. So that is all of the prepared remarks that we have today. And we do have, I do see we have one question here, so we'll take a look. I'm an Indian citizen currently living in Canada as a permanent resident, and I'll be eligible to apply for Canadian citizenship in 2025. I own a Canadian IT consulting company with over $1 million in projected revenue. Okay. Based on the profile and long-term goals, would you? Well, I think that, yeah, so it's a great question, because the crux of the question is really that you have a business in Canada and you have operations there, and you want to know if an L1 or an E2 is the best option. Really either could be an option. It just depends. I think that L1, usually when someone's eligible for both an E2 and an L1, then an E2 is a better option, because for a Canadian they can get 5 years, where versus a new office L1, it's 1 year, and then you have to renew, and you have to ramp up employees very quickly, at least have 5 in the first year in order to renew. But there could be situations where the individual doesn't really want to invest much, because L1 doesn't require much, if any, investment, whereas E2 does. So some people might opt for an L1. But we definitely have webinars on L1 and E2 as well. So definitely feel free to sign up for those and kind of ask more questions on that, because this particular webinar really is a focus on moving from a non-immigrant visas to green cards. So I see another question kind of related, is starting with an E2 or switch to EB1C. Yeah, so that's a great question related to this webinar. So absolutely. So you don't need an L1A to switch to EB1C. So one green card that we didn't talk much about here, just because it's often related to larger companies, is that there's an L1 non-immigrant visa where people can convert to a green card, which is called EB1C. And the criteria for EB1C are very, very similar to the criteria for L, except again, almost like the O1 EB1A context, it's EB1C is L1 squared. So a lot more in terms of what is required, even though the requirements look the same on paper. Now, the one of the requirements is that you have to work for the company for one year in the last 3 years, and then there has to be a qualifying relationship. And as I said, those requirements are really similar between L1 and EB1C. So so then when it comes to can someone move from E2 to EB1C, you don't have to be on an L1A, and there's no benefit necessarily of being on an L1A if you want to move to EB1C. The one kind of maybe hidden benefit is that if you're on L1, then you've at least met the threshold requirement. So you may not have exactly the level or the kind of as enough to move to EB1C, but at least you've met the requirements of working for the company for 1 year, there being a qualifying relationship, having an executive capacity, and you just have to then see for EB1C whether it's enough, right? Because even though the requirements look the same, you would have to see whether in fact it was enough. So. Excellent. So thank you very much. I don't see any more questions here. Let me just check one more time here. No, I don't see any more questions. And definitely, as I said, we're going to send a copy of the presentation. We're going to send a copy of the link to set up a consultation. And we will also send a link where you can see the webinar on YouTube. Thank you.